start over again. So here we go. Good morning. My name is Adrienne Roberts Larson. I am the Chief Deputy for the Department of Taxation. Today is Tuesday, October 7th, 2025, and the time is now 9:07 a.m. This is the time and place for a public meeting to conduct a workshop on proposed permanent regulation of the Nevada Tax Commission to enact regulation in NAC 369 in support of AB 375 and AB 404 of the 83rd session. As required by NRS 233B.061, this meeting has been noticed in accordance with the Nevada Open Meeting Law. I am attending this workshop from the Department of Taxation's Reno office as provided on the notice of workshop and meeting agenda. Joining me in the Reno meeting locations are department staff and Carrie Skalski, our Management Analyst 3. The department has also made this meeting available to the public via Zoom. Accordingly, if you wish to provide comment during the meeting, please raise your hand on the Zoom and staff will unmute you. In accordance with the open meeting law and the agenda for this workshop, we will start with the agenda item 1, public comment. Please note the purpose of this agenda item is for general public comment. If your comment relates to the language of the regulation, which is the purpose of today's workshop, please hold that comment for discussion during that agenda item. The department will take public comment related to the regulation with that agenda item. As we have agendized this meeting for virtual appearances, AB 219 from the 2023 legislative session requires that we verbally read the instructions prior to the first public comment period for a member of the public to call into the meeting to make public comment. Accordingly, Carrie, will you please read into the record our instructions for how a member of the public may call into the meeting for public comment?
To join by phone, dial a number based on your current location, such as 1-669-444-9171. Persons wishing to provide public comment remotely may access the meeting by using the telephone numbers and meeting ID posted on the agenda. Public comment will be limited to 5 minutes per person, and comments based on viewpoint will not be restricted. Public comment will be available at the beginning of the meeting and at the end of the agenda. At the discretion of the facilitator, additional public comment may be heard when that item is reached. The facilitator may allow additional time to be given to a speaker as time allows at their sole discretion. NRS 241.020, NRS 241.030. If you would like to make public comment and you are attending on Zoom, please raise your hand. Those attending on the telephone, please dial *9 to be put into the queue. If you are attending remotely and would like to make public comment, please respond to the questions in the Q&A. No one has raised their hand or pressed *9.
Thank you, Carrie. And see no public comment here in Reno, we will continue on. Agenda item 2, workshop for AB 375, Section 1, and AB 404, Section 4. In the current phase, we have proposed some language for the workshop, but have not submitted that language to the Legislative Counsel Bureau. Today, we are holding the workshop with the public for any feedback related to the proposed language or other suggestions related to this topic. After the workshop, the department will review any suggestions, concerns, and submit language to the Legislative Counsel Bureau, LCB, for consideration. The LCB will provide a proposed draft, and if there are no substantive changes from what is talked about today, we will bring forward the regulation to the Nevada Tax Commission for a formal public hearing and adoption of the regulation. If language is different than today or substantive recommendations are provided to alter the language greatly, the public will be provided 30 days notice of this public hearing for the adoption hearing. If this regulation moves forward in its current form, it is expected to be heard by the Tax Commission during its December 2025 meeting, pending receipt of proposed language. Dependent on the proposed language and discussion today, upon receipt of the proposed draft, the department will notice the hearing with a copy of the regulation and hearing date before the Tax Commission for adoption or additional workshops if needed. Once again, if the Tax Commission makes substantive edits, the regulation must be submitted back to LCB for revised language before final adoption at a subsequent hearing. Upon adoption by the Nevada Tax Commission, the regulation will be presented to the Nevada Legislative Commission for its review and approval. And upon approval by the Legislative Commission, it will be filed with the Secretary of State, at which time it will become effective as a matter of law. All of the Tax Commission's proposed and adopted regulations are posted on the department's website pending codification by LCB into the Nevada Administrative Code. draft, and adopted regulations can also be located on the Nevada Register published by LCB. Substance of the regulation. So with that background, I'm going to provide a brief overview of the substance and the regulation itself. A regulation relating to intoxicating liquor imposing a surcharge on such sales that are authorized by an ordinance adopted by the Board of County Commissioners of the county and the governing body of an incorporated city authorizing certain food establishments to sell or deliver alcoholic beverages for consumption off the premises of the establishment under certain circumstances. A regulation relating to the electronic funds transfer requirement included in AB 404 of the 83rd session, providing guidance and administration and other such matters relating thereto. Existing law authorizes certain establishments to sell alcoholic beverages by the drink for consumption on the premises of an establishment, NRS 369.090 and 369.620. Existing law also authorizes a retail liquor store or delivery support service acting on behalf of a retail liquor store to deliver liquor in its original package to a consumer in connection with a retail sale of such liquor under certain circumstances, NRS 369.489. AB 375 defines covered food establishment to mean in general a food establishment that prepares and serves food on the premises and which is licensed to sell at retail alcoholic beverages for consumption on the premises. AB 375 authorizes the Board of County Commissioners of the county or the governing body of an incorporated city to enact an ordinance authorizing, under such conditions as may be imposed by the ordinance, a covered food establishment to sell at retail an alcoholic beverage in a container sealed by the establishment for consumption off the premises of the establishment. AB 375 also authorizes the ordinance to authorize a covered food establishment or delivery support service acting on behalf of such an establishment to deliver alcoholic beverages in a container sealed by the establishment to a consumer in connection with the retail sale of an alcoholic beverage. AB 375 requires the Department of Taxation to adopt regulations that provide for the imposition and collection of a surcharge. This regulation sets that surcharge at 50 cents for each retail sale of an alcoholic beverage subject to the surcharge. AB 375 requires the revenues collected from the surcharge to be distributed, 1, to the department in an amount determined to be necessary by the department to pay the costs of the department in carrying out the provisions of Section 1, which must not exceed $250,000 each year, and 2, if any money remains, to the account for the ignition interlock and DUI reduction program to be used for the purposes for which the money in the account is used. AB 404 made changes to NRS 369.485, requiring electronic fund transfer and/or credit cards for the payment of purchases made between wholesaler and retailer. We have received public comment from Mark, probably going to butcher this last name, sorry, Susio and Wendy Turk. If they would like to speak to their comments, now is the time. If not, we will accept the comments that were provided to us and move forward. Yes, come on up. Thank you. Please state your name. Good morning.
Thank you very much for having me. It's an honor to be here and to be able
It looks green from my side.
Oh, there we go. Now it's green.
There we go.
Okay. Try it again. Do you want me to
I think you
test
can
it?
just continue on.
Okay, pick up where I left off?
Yes, please.
Okay, thank you. While our company is honored and eager to help the industry become compliant with AB 404, I have taken questions from many industry members in Nevada that I haven't been able to answer. So my comment today is actually a list of questions that I would ask the department to clarify during their rulemaking. Question number 1, will the law apply to deliveries made to special event permit holders? Question number 2, with regard to electronic payment transactions, how many NSF or non-sufficient funds returns, or how may they be repaid? Question number 3, how may closed account returns and or frozen account returns be handled? The banking laws do forbid them from being reattempted via ACH, so there would need to be another solution there. Question number 4, the new law mentions twice that retailers may elect to pay via credit card. My question is, does that mean that the retailers may elect to pay by credit card only if the distributor offers it as an option? Or does it necessarily require that all wholesalers offer a credit card option? And then finally, question number 5, when and how will the conflict between the codified language from AB 404, which requires electronic payments, and the proposed language in NAC 369.055, which essentially makes electronic payments optional, when and how will that be settled? And those are my questions. Thank you so much for your time.
Thank you. All right, with that background and context, I'll now open the workshop for discussion among members of the public who wish to provide feedback or ask questions. We will address comments, questions from those attending in the workshop in person here in Reno, followed by comments from members of public attending via Zoom. Please raise your hand on the Zoom and Carrie will call on you for comment. And so before you get started, I'll just mention this is agenda item 3, public comment. Please state your name for the record. Is this specific to you? Did I skip forward?
This is specific.
Haven't finished my coffee/tea this morning yet, so forgive me. Yes, please continue on. Thank you. Please state your name.
Good morning. Go over that again, or no problem. The language in front of you is from DoorDash, and also supported by Amazon, and Mr. Scott Gillis will offer his comments later. And that is to insert the language by a covered food establishment in the proposed section 1, just so it's consistent with the law and to avoid any confusion over who is subject to the surcharge. And also add the word covered food before establishment in subsection A, just for consistency. And those are our suggestions.
Thank you very much.
Great. Thank you.
Is there any other public comment or comment specific to this here in Reno?
We have one member on Zoom who has raised his hand. It's Mark Suthio that submitted the written public comment, so I'm going to allow him to talk now.
That's fine. Thank you.
Good morning. I just want to make sure everybody can hear me.
We can hear you.
Great. Good morning, Mark CQ. I am the owner of the Cask Wine and Beer Boutique in Henderson, Nevada. Our address is 19 South Stephanie, suite number 180, telephone 702-331-1348. I just wanted to add comment in regards to AB 375, cocktails to go. My only request to this would be that retailers such as myself that hold a dual license in their city that have the capability to make cocktails on site would have the capability to be able to also participate in cocktails to go. We would like to be able to just have the same and equal playing field to our on-premise licensee holders as well, since this does create a little bit of an overlap with license holders that hold on-premise licenses now being able to deliver and serve off-premise. I do believe that since we do have the capability to be able to make cocktails on site at our store because of our dual license, we should be able to also serve cocktails to go through DoorDash if they are elected to be able to do so, as well our own capabilities for local delivery, which we currently have in the city of Henderson exclusively. Thank you for letting me participate today.
Thank you. Okay, back to here in the Reno office. Please come forward. Good morning.
Good morning. I have a, excuse me, I have a green light here, so.
I was going to ask you to make sure. All right,
that's
please state your
working.
name. And
My name's Leaf Reed. I represent the Nevada Beer Wholesalers Association, and we want to thank the department for the work that went into the proposed regulations. Very brief comments. The first is with respect to the new regulation relative to AB375, and that is to just request a clarification. I think it states this in the statute, but just to make clear that suppliers that have a restaurant, that are, the people who are making the liquor product themselves cannot themselves deliver. We think that's prohibited under the statute and under the three-tier system, but just wanted to clarify that. And then with respect to the regulations for AB404, we would request that some language be added that would allow for wholesalers to require new customers to be placed on EFT, and also with respect to delinquent payments, that wholesalers be permitted to as when a customer is delinquent to require them to be placed on EFT terms. That's the extent of our comments, and I appreciate your time.
all right, thank you very much. Is there any other comment here in Reno specific to the regulations? Carrie, how about on Zoom?
We do have another member on Zoom. Virginia Valentine would like to make public comment. And Virginia, if you could provide the information requested in the Q&A after you make your public comment, that would be appreciated.
Thank you. Can you hear me?
I can hear you.
Great. My name is Virginia Valentine, and I'm speaking today on behalf of the Nevada Resort Association. We represent 72 resort hotels across the state, and we appreciate the opportunity to speak on the draft regulation and express our concerns. While AB 404 was intended to support Nevada's craft brewery industry, a late amendment imposed an unprecedented and unnecessary state mandates on transactions between liquor retailers and liquor wholesalers. Specifically, it requires payments to be made exclusively by electronic fund transfers or by credit card. It places all fees on retailers and grants wholesalers the authority to directly withdraw funds from the liquor retailers' bank accounts within 30 days. These previous provisions override the ability of private businesses to negotiate their own terms, removes flexibility, and imposes extraordinary state involvement in what have traditionally been free market arrangements. Importantly, conversations with the bill sponsor was not clear, and it was not his intent that he expressed support for quick, swift corrective action. The legislation is setting a dangerous precedent by inserting itself into the relationship between liquor wholesaler and the liquor retailer to dictate payment terms between private buyers and sellers. Further, it is unnecessary as wholesalers already have the ability to stop selling to retailers who do not make timely payments. We are unaware of any other circumstance other than those that are court ordered in which payments can be taken without permission from a private party's accounts by another private party. Given that the Department of Taxation cannot intervene in payment disputes because it has not been given the authority over this situation, if the EFT language is not addressed, the only path to resolving payment disputes will be expensive civil litigation, which does not benefit either party. Given that the department, without an immediate remedy, the legislation will create confusion and costly implementation hurdles for wholesalers, retailers, the Department of Taxation, and third-party processors. New banking systems, application, and staff training would need to be in place within a short and impractical timeline, all of which will create significant costs for businesses as they change current IT systems, implement new EFT accounting measures, and deploy training. Note that under the amendment and the proposed regulations, all cost of compliance will be borne by retailers for the convenience of wholesalers. Furthering, being allowed to access complex IT systems creates potential security risk for the retailers. We appreciate the language in the proposed regulations, and if the statutes were clear that paying an EFT would only happen by agreement of mutual consent between the parties, that would be much better. But such agreements were not mentioned in the amendment, and the department's enforcement authority is unclear in this situation. We have long enjoyed a mutually beneficial relationship with the wholesale liquor industry, and we're very saddened to see that they have taken such a heavy-handed approach when they have other options to resolve payment disputes. We truly appreciate the department's proposed amendments to NAC 369.055, accordingly in support of the changes instituted by AB404 of the 83rd session. But unfortunately, these amendments cannot address the problems with the legislation. Thank you.
Thank you. Any other comment on Zoom, Carrie?
We do. We have 3 on Zoom. Let's start with Becky.
Are you able to hear me?
I can hear you.
This is Becky Dutra with Nevada Taxpayers Association. Just in everyone's respective time, I will just ditto everything that was said by Ms. Valentine with Nevada Resorts Association. The Nevada Taxpayers Association has a lot of the similar concerns, especially the mandate put in state that is mandating transactions between businesses. Thank you.
And now we have Nick Snyder.
Good morning, and thank you for giving us the opportunity. This is Nick Schneider with the Director of Government Affairs for the Vegas Chamber. For the sake of brevity, we'll also echo the comments by Virginia Valentine. We appreciate the work that y'all have done, and do still have some concerns regarding the direct withdrawal of funds. We're working with our members to provide any additional feedback. Thank you so much.
And we have Brian Watcher.
Good morning, Brian Walker on behalf of the Retail Association of Nevada. We too echo the comments of Ms. Valentine from the NRA, as well as the comments from the Vegas Chamber and the Taxpayers Association. Specifically in regards to the regulation, is wanting to make sure that the option for that credit card payment was included. We think it's very clear by statute that both options are to remain viable. And I think that's very important, especially for our smallest retailers who are not as sophisticated and maybe having different problems. And we understand and agree with the Resort Association that there are other methods of dispute resolution and that we highly encourage the legislature to re-examine this issue. Thank you.
I do not see any other hands raised. If you are on the telephone and you would like to make public comment, please press *9 now. Do not see any other members wishing to make public comment at this time. If you did provide public comment and you are participating remotely, if you could please answer the questions in the Q&A, providing your name, email, organization, address, and phone number, that would be greatly appreciated.
All right, so I think our specific comment of public comment may have been a little meshed there. So just to be clear, that was for our specific comments. Is there any public comment? In Reno, on Zoom? All right. Hearing and seeing none. Then that will bring us to our adjournment. And I believe that is it. So thank you everyone for being here today in Reno. Thank you for everyone who participated via Zoom, and have a good rest of your day.